Welcome to the deep dive. We are jumping into, well, one of the most practical and maybe challenging corners of contract law, the enforceability of oral promises.
Uh-huh.
Specifically, when does a verbal guarantee, promising to cover someone else's debt, actually hold up in court?
Yeah, it's tricky because we often start with this default idea that guarantees have to be in writing. That's the statute of frauds, right?
Right.
But the law, well, it recognizes that sometimes an oral promise to pay a third party's debt isn't really about generosity. Sometimes it's made out of, pure calculated self-interest.
Okay, so that tension, the formal legal rule versus, let's say, the real-world motivations, that's our focus today.
Exactly.
Our mission, then, is to understand precisely when that self-interest is enough to override the need for a written agreement, for a signature.
Mm-hmm.
And to do this, we're going to look closely at a specific case from the Supreme Court of Arizona, Yarbro v. Neal B. McGinnis Equipment Co. It's a really great study involving a tractor, repeated payment defaults, and a crucial verbal assurance.
Yeah, it's a classic. And to really understand it, we have to get comfortable with two distinct legal doctrines.
Okay.
First, we need to establish the basic rule, the statute of frauds and its specific provision about suretyship promises.
Got it.
And second, we immediately look at the powerful judicial exception, the one designed to prevent unfair results.
Yeah.
It's known as the leading object exception, or sometimes the main purpose rule.
Leading object. Okay.
And we'll model a very structured, element-by-element analysis to see exactly how courts draw that line. Is the promise really for another's debt, or is it deep down for your own?
All right. Before we get into the tractor troubles in Yarborough, let's lay that foundation. Which specific part of the statute of frauds are we talking about here for these kinds of promises?
We're zeroing in on Arizona Revised Statutes, Section 44101, subsection 2. It's short, but packs a punch.
Okay. What does it say?
It says essentially, no action shall be brought to charge a person upon a promise to answer for the debt, default, or miscarriage of another, unless that promise is actually in writing and signed by the person you're trying to charge.
So simple enough on its face. An oral promise to be a surety, a guarantor. It's just unenforceable.
Well, yes, if it's what the law calls a collateral promise.
Collateral meaning...
A collateral promise means the person making the promise is just a secondary source of payment, like a backup plan. If the main debtor defaults, then the promisor steps in. The statute of frauds applies squarely to those situations to prevent, false claims against supposed guarantors.
Okay.
But crucially, the statute does not apply to what we call original promises.
Original.
Yeah, original promises are made more at the promisor's own request and really primarily for their own benefit. It's not just about backing someone else up.
Okay, that distinction makes conceptual sense. But, an oral promise is invisible. It's just words. Why would a court ever enforce an oral promise that seems to fall right under the statute of frauds rule? What's the thinking there, the policy?
That's really the key insight, isn't it?
Yeah.
The statute of frauds exists to prevent fraud, right?
Yeah.
By demanding written proof.
Sure.
But think about it. If the evidence overwhelmingly shows the promisor was acting purely out of self-interest, well, the risk of a fraudulent claim kind of fades away. Their actions speak louder than the lack of a signature.
So the promisor's obvious self-serving motive almost proves the promise was real better than a piece of paper could.
Exactly. That's the logic. When a court sees clear evidence that the promisor was mainly protecting their own interest, they bring in the leading object exception.
Okay.
And the rule for that exception is, where the leading object, the primary purpose of the person making the promise, is really to protect their own financial immediate interest, then that promise is valid. It's enforceable, even if it was just oral.
So everything hinges on figuring out that true self-serving motive. What are the specific things, the elements we need to look for to prove this exception actually applies?
Right. It's not just a gut feeling. You need to prove two main elements based on the facts.
Okay, what are they?
First, the promisor must have a personal, immediate, and pecuniary interest in the underlying transaction. It can't be some vague, distant benefit.
Personal, immediate, pecuniary. Got it. And second,
that benefit to the promisor has to be the primary object, the main purpose for making the promise. It needs to be clearly distinguishable from a benefit that's just, incidental or indirect or kind of remote.
okay, that distinction between primary and incidental seems like where things could get sticky.
Absolutely. That's often the battleground.
All right, let's put this to the test. Let's analyze Yarbro v. Neal B. McGinnis Equipment Co. using that structured approach you mentioned. So, first things first. What are the legally dispositive facts?
Okay, the background is crucial here. Back in 1957, a guy named Russell buys a used HD 5G tractor from McGinnis Equipment Company. It's on a conditional sales contract, meaning McGinnis keeps title until it's paid off.
Standard stuff.
Right. But here's the kicker. Yarbro, the defendant in this case, had already tried to buy that exact same tractor himself.
Oh.
Yeah, but his credit wasn't good enough, so McGinnis turned him down. Then, almost immediately, Russell defaults on the very first payment for the tractor.
Okay.
So Yarbro steps in. He pays that first installment for Russell. And importantly, Yarbro starts using the tractor for work on his own ranch.
Ah, okay. So he gets access to the equipment he couldn't buy directly.
You got it. Then, over the next year or so, Russell keeps defaulting, like repeatedly. McGinnis Co. threatens to repossess the tractor multiple times.
In Yarbro.
Each time Yarbro intervenes, he makes oral promises to McGinnis Co. saying he'll bring the account current. And critically, he tells them why. He says he needs the tractor for jobs on his ranch. He even issues a couple of checks to cover past due amounts, but they bounce. Bad checks.
Oof.
Yeah. But based on these promises, McGinnis Co. holds off on repossession several times. They're waiting for Yarbro to get funds he claimed were coming from, like real estate deals and oat crops.
But the money never showed up.
Never fully arrives. Eventually, McGinnis Co. runs out of patience, repossesses the tractor, and then they sue Yarbro for the delinquent payments he'd promised to cover.
Okay, that sets the stage really well. So what was the core legal issue the court had to decide?
The main question was pretty straightforward. Was Yarbro's oral promise to pay Russell's overdue payments legally enforceable? Specifically, did it fall under the leading object exception to the statute of frauds? And if it was enforceable, how much did he actually owe? What was the scope of his liability?
Got it. And what rule of law did the court apply to answer that? Can you state the full black-letter rule and break down its testable elements again for us in this context?
Sure. The court applied the leading object rule, just like we discussed. The core principle is a promise to pay another's debt is enforceable, even if oral, if the main purpose of the promiser isn't just to act as a surety, but rather to serve some personal interest of their own.
Okay.
And in applying this, the court essentially focused on proving three key elements based on those facts.
All right. What were they?
1. Was Yarbro's action motivated by self-interest? Meaning, was the benefit he sought primary, immediate, and pecuniary?
Okay. Self-interest. 2.
2. Was his promise supported by sufficient consideration? Did McGinnis give up something of legal value in return for the promise?
Consideration. And 3.
3. What was the actual scope of the liability Yarbro assumed with his words? Did he promise to pay everything or just certain parts?
Thank you. That's very clear. Now for the court's elemental analysis. Let's walk through this step by step, just like a court would. How did the court apply that first element, the self-interest and primary object part?
Right. So the sub-issue here was Yarbro's desire to keep that tractor just, a minor side benefit of helping Russell? Or was keeping the tractor the main, financially driven reason for his promise?
And the application. What facts did they point to?
Well, the court looked at the whole picture. Fact 1, Yarbro tried to buy the tractor himself first. That shows direct interest. Fact 2, he was actually using the tractor for his own ranch operations. Fact 3, when the repair person needed to find the tractor, they found it on Yarbro's land. And fact 4, maybe the most telling, Yarbro explicitly asked McGinnis Co. not to repossess because he needed it for his work, for his livelihood.
So putting all that together,
The court concluded that Yarbro's leading object, his main goal, was clearly to secure a financial advantage for himself specifically, continued access to that essential piece of farm equipment.
which means his promise wasn't just a collateral guarantee for Russell.
Exactly. It was treated as an original obligation. He was promising to pay, effectively, for his own benefit, making it potentially enforceable, even though it was oral. Element 1 was met.
Understood. Now, what about the second element, sufficient consideration? You mentioned he kept promising but failing, even wrote bad checks. Why wasn't that seen as, evidence that the promise wasn't really solid, maybe not really bargained for? How did they find sufficient consideration from McGinnis?
That's a fair question. The court didn't really focus on Yarbro's reliability after the fact. For consideration, they looked at the moment the promise was made and what was exchanged then.
Okay.
The sub-issue was, did McGinnis Co. give up a legal right, suffer a legal detriment in exchange for Yarbro's promise?
And did they?
Yes. McGinnis Co. had the absolute legal right, under the sales contract, to repossess that tractor the moment Russell defaulted.
Right.
But the evidence showed they didn't exercise that right.
Right.
They forbore from repossessing. And critically, they did so because Yarbro kept promising he would pay the overdue amounts.
Ah, forbearance again. So giving up their right to repossess was the consideration.
Precisely. That act of forbearance was a legal detriment to McGinnis Co. They
Right.
delayed getting their collateral back, and it was obviously a substantial benefit to Yarbro he got to keep using the tractor he needed.
Okay.
So the court found there was good and sufficient consideration to support Yarbro's oral promise. Element 2. Check.
All right, so the promise is enforceable because it meets the leading object exception, self-interest consideration. Now, after analyzing all those elements, what was the court's final conclusion? Especially about the total amount Yarbrough actually owed. You mentioned the scope was important.
Yes, this is where it gets really interesting and it shows the precision required. The court definitely found the promise was valid and enforceable under the leading object exception. But the Arizona Supreme Court stepped in and modified the amount the trial court had awarded. The trial court initially said Yarbrough owed the entire remaining balance on the tractor contract, over $8,700.
Wow, so why did the Supreme Court change that if his promise was enforceable?
Well, it goes back to element 3, the scope of the promise. The higher court looked very carefully at the specific words Yarbrough used.
Okay.
And the evidence only showed that Yarbrough specifically promised to pay the past due and delinquent payments, the amounts that were already overdue, up through about July 1958.
He didn't explicitly say, I'll take over the whole contract.
Apparently not clearly enough. He might have made some general statements about taking it over, but the court felt that wasn't specific enough to legally obligate him for all the future payments Russell might miss.
So the ruling was more nuanced.
Exactly. The court basically said, just because you promised to cover someone else's debt to serve your own purpose doesn't automatically mean you've promised to cover the entire debt, present and future.
So in the end, Yarbrough was only liable for those specific overdue monthly payments he actually mentioned, from October 57 to July 58.
That's right. His liability was limited to the scope of his actual evidenced promise, not the whole remaining contract balance. It's a really vital distinction. The exception makes the promise enforceable, but only as far as the promise actually went.
That makes sense. It limits the risk for someone in Yarbrough's position, even if their oral promise is enforced.
Definitely. The law enforces the promise made, not necessarily the entire underlying obligation of the original debtor.
Okay, this concept of primary versus incidental benefit is key. Let's try to make it even more concrete, maybe a bit visceral, with a hypothetical.
Sure, hypotheticals are great for this.
All right, imagine you have a professional food caterer. Let's call her the promiser. She's hired a very specialized, unique food truck, the debtor, for a huge, incredibly profitable 3-day smatable. This contract is make or break for her year.
Okay, high stakes.
Very high. Suddenly, the food truck owner gets served papers by his mechanic, the creditor. The mechanic is about to repossess the truck right now because of $5,000 in overdue repair bills. If the truck goes, the caterer's festival contract is totally ruined.
Disaster for the caterer.
Right, so the caterer runs over to the mechanic and says, orally, stop. Don't take the truck. I need it for the festival. I'll pay you that $5,000 bill myself next week. Is that oral promise enforceable against the caterer?
Oh, absolutely. Yes. That promise is almost certainly enforceable under the leading object rule.
Why so clearly?
Because look at the caterer's motive. Her main object, her primary purpose, isn't charity towards the truck owner.
Right. No, she needs that truck.
Exactly. She's protecting her own immediate pecuniary interest, that massive profit she stands to make from the festival contract. Losing the truck isn't just inconvenient. It means a direct, catastrophic financial hit to her.
So the benefit of keeping the truck running is primary, immediate, self-serving.
Precisely. If it's all the criteria. The promise stems directly from her own financial need, making it an original obligation under the exception. It's the same core principle we saw in Yarbro. Her promise is valid, even though it was oral.
It really boils down to, if you stand to personally gain or lose significantly, your promise is probably about you.
That's a good way to put it. The focus shifts from guaranteeing another's debt, which needs righting, to securing your own benefit, which might not. So for you listening, especially if you're facing, say, a contracts exam or just trying to analyze a real-world situation with an oral promise like this, having a clear framework is essential.
Okay, let's synthesize what we've learned into that kind of step-by-step checklist. How should someone approach this?
All right, here's a diagnostic checklist based on our discussion. Step 1. Issue spotting. Does the scenario involve someone making an oral promise to pay the debt or cover the default of another person? If yes, you've got a potential statute of frauds suretyship issue.
Okay, flag it.
Step 2. State the initial rule. Note that the statute of frauds, like ARS Section 44 and 101, subsection 2, generally requires such a promise to be in writing to be enforceable. Lay down the baseline.
Baseline established.
Step 3. Check for the exception. Ask, did the person making the promise, the promiser, receive some kind of direct, personal, immediate financial benefit from making that promise? If the facts suggest yes, then you immediately pivot to the leading object exception. Mention the policy. The self-interest reduces the need for the writing.
Trigger the exception. Got it.
Step 4. Elemental analysis. Now, you rigorously test the promise against the two main elements of the leading object rule. Element A, primary object. Was the promiser's main purpose self-serving, like Yarbro needing the tractor or the caterer needing the food truck? Was it about securing profit, protecting property, keeping a business running?
Okay, analyze motive.
Element B, consideration. Was there valid consideration for this specific promise? Look for evidence of the creditor giving something up, like forbearance from repossession, as McGinnis did, or some other direct benefit flowing to the promiser because of the promise.
Find the exchange.
Step 5. Conclusion on enforceability. If you find evidence supporting both the primary self-serving object and sufficient consideration, then you conclude the oral promise is enforceable, despite the statute of frauds, thanks to the leading object exception.
Makes sense?
Step 6. Analyze the scope. And this is crucial. Don't forget this last step based on Yarbro. Critically examine the specific language of the oral promise. Did the promiser agree to cover the entire debt, or only certain past due amounts, or payments for a limited time? The liability is limited to what was actually promised.
Right. Don't overextend the liability. That's a really practical framework. What really stands out to me from this whole deep dive is how the law tries to balance these, formal requirements, like needing a signature for a guarantee, against the messy, practical realities of why people actually make promises. Yarbro's promise wasn't treated like some casual favor for a friend. The court saw it for what it likely was, a business transaction, driven primarily by his own need for that tractor.
Yeah, it's a great illustration of courts sometimes looking past the strict form to get to the substance of the transaction, especially when someone's self-interest is so obvious on the facts. It prevents the statute of frauds itself from being used, ironically, to achieve an unfair result.
Okay, so here's a final thought to leave you with. We saw clearly that McGinnis Co.'s forbearance, their decision not to repossess while Yarbro was promising payment, was key. That was the consideration.
Right.
But how might things have played out differently if McGinnis Co. had already repossessed the tractor? Let's say it's sitting in their lot. Then Yarbro comes along and makes an oral promise to pay the past due amounts if they'll just return the tractor temporarily.
Interesting twist.
Does that change the consideration analysis? Is the promise now just trying to undo a past action, maybe making it look more like an unenforceable promise to pay an existing debt? Or is the return of the tractor a sufficient new consideration? Does that timing matter? Something for you to think about next time you encounter a tricky contract situation.